Myers, Myers, representing Mr. Roberson.
Good afternoon, Judge. This is Emily Lynn, Linn, also representing Mr. Roberson.
All right, and I think obviously we have Mr. Roberson here, as well as another, it looks like another feed from TDCJ, and I think that takes care of everybody that's actually here. And Ms. Swin, I want to apologize. I think in all of our previous hearings, I may have referred to you as Ms. Sween. I didn't, is it Swin?
You and everybody else on the planet who reads English, so don't worry about it.
Well, all right, then let's, we set this today to have an opportunity to sort of conference after everybody had made their respective filings. And I guess let me give you all the opportunity. If there's anything sort of opening wise you feel like you need to add, I'll tell you, I've not read through all of the documents that the defense provided to our office yesterday, all 11 volumes. But I have read through, of course, the initial filings and the state's response. And so I'm familiar with it. I'm not really looking for argument at this point, but if there's anything last minute that hasn't been brought up that you feel like needs to be addressed, I can give you an opportunity to do that. Otherwise, I've just got some general questions that I'd like to start with. Is there anything that either side feels like they need to take up before we get started?
Your Honor, if I may just, I will try to keep it short, but I would like to make one statement on the record.
Sure.
That I feel I'm experiencing a very bad case of deja vu that unfortunately, as anticipated, after 6 months, most of the state's answer was cut and pasted from previous filings, including a very adversarial summary of the trial record that includes overwhelming numbers of basic mistakes. I'll give you one tiny example. To try to malign Mr. Roberson, they suggest he didn't get Nikki to the hospital till after a phone call at 10 a.m. to his girlfriend, when the medical records show that by 9:50 a.m. she had been admitted, a code blue had been initiated, her heart had been restarted, she'd been found to be in tachycardia, and she'd been intubated. So this case shouldn't be about rehashing arguments that have been rebutted and testimony that has been deemed irrelevant. And also back to 2016, when we had the remand, the state also argued there didn't need to be any further factual development. And here we are again, the same position. And even Judge Evans, who was then new to the case, recognized that was not a reasonable response to what the CCA had ordered. And I suggest, Your Honor, that's the same that's true today. But their thesis does seem to be that somehow you're locked in to these findings that were made in 2022. And I suggest there could be a reasonable way to say, well, we go back and look at those findings and see which ones withstand scrutiny in light of the trial record, the post-conviction evidence, and now ex parte Rourke. That might be a reasonable way to start this off. But to just presume findings that have been attacked, and that's one reason we're still here today, are to be just blindly accepted is not a good faith argument, we suggest. And again, we have lodged objections years ago to those findings that have never been considered or ruled upon. And if Your Honor would like to take that up as the next measure, we could certainly do that, although I suggest you probably don't want to do that today. So I'll stop ranting, but I do feel a bit morally affronted that the state's answer seems to about trying to inject bias against Mr. Roberson based on a completely bogus representation of the record, when this is supposed to be about science. This is an Article 11073 proceeding. It's not about what his highly impaired ex-girlfriend was pressured into saying, or what his conflicted, unethical, retained experts said against his wishes in the 2003 trial. I'm sort of beside myself by how much misinformation there is in the filing.
Yes, Mr. Bragg, any response on that? And I will say, like, obviously, the record is what it is, as far as what it reflects people said or did, and Ms. Swin, I don't mean to discount your frustration, but I don't know that that's the particular issue before us today. But Mr. Bragg, if you want to respond to that, you certainly can.
Certainly, Your Honor. I think I'll pick up right where you left off. I don't. It does not surprise me that opposing counsel is, dismayed by our representations in the record. There was a trial that was had, and applicant Mr. Roberson was found guilty. And what 1107.3 says is that we are to take the trial that happened. We are to take whatever new science, if indeed there is new science, which this court found there was a development in the science since the trial. We're to take the new science and we're to apply it to the trial as it happened and determine whether or not that would undermine the conviction. I certainly understand opposing counsel's, protestations about a conflicted expert or trial counsel's behavior or what have you, but those claims are not before the court. The court does not get to go back and redo that part of the trial. It has to take that part of the trial as has happened. So leaving that, I want to actually focus on a couple of things that opposing counsel said, because I think they are at the core of where we're at right now. Opposing counsel made the claim that their objections had never been ruled on from the 03 hearing. In fact, that's not true. Their objections have now been ruled on twice. The objections were essentially overruled when the CCA adopted this court's findings in denying relief in the 03 proceeding, in the what I call the 2000, or it's not 2003, excuse me, the 03 writ proceeding. Importantly, though, and the reason why it's not just a thesis, Your Honor, that this court is locked in, it is the remand order that locks you into that proceeding. Applicant himself pushed the reconsideration of the 03 and 04 writs in all of the filings that occurred around the 05 writ that's now been considered. And it is important to note that when issuing this order, the CCA, we're back here on a reconsideration. Now, these suggestions for reconsideration, it's a bit of a legal fiction that we kind of play because, of course, the rules prevent applicants from filing true motions for reconsideration. So often what happens is they file suggestions and the court sometimes rules on it, sometimes doesn't. There are suggestions for reconsideration that are still pending in the court that will pin forever because the court's just not going to take it up. But here, there was a suggestion for reconsideration on the 03, 04, and 05 writ, and the court expressly ruled in their per curiam majority opinion, expressly ruled on all three, granting the remand, the reconsideration and remand of the 05 application, but denying reconsideration of the 03 and 04 applications, which means that the 04 application is still dismissed under Section 5 and still jurisdictionally barred from this court considering it. The 03 application is still set. It cannot. Now, let me, and I want to be clear about the position. I think the briefing lays it out clearly, but our position, the state's position, is that really what the court has before it is a pure question of law. To opposing counsel's point, the state may have, I have no doubt the state argued that there was no factual development that was needed at the 03 during the 03 proceeding. But what is vastly different from that proceeding to this proceeding is that factual development on the factual questions at issue here has already occurred. Rourke's impact on those facts is a legal analysis, just like any other. You have a Brady claim, you develop facts on that, and then you take Brady or other case law and you say, how does the case law apply to the facts at hand that have already been developed? The facts here have already been developed, and I think I will just quickly say, Your Honor, because I haven't had a chance to respond to it yet. My response to the application and my discussions on the CCA remand are all before the court in our pleading, but what I haven't had a chance to respond to is applicants' proposed ODI, and this actually all comes from the proposed ODI, not the motion itself, but the proposed ODI that it would have the court sign. I would point the court first that it says applicant's claim could not have been presented until the 05 writ because of Rourke. And this mirrors exactly what they said in the 05 application. The 05 application is all about the new legal basis. And in fact, you'll see in my briefing where I note that when they're citing section 5, they italicize new legal basis, meaning that's what they're proceeding on. They reiterate that in the new proposed order. This is a new legal basis. But more importantly, when you look at the controverted facts section, they have 1, 2, 3, 4, kind of list out the factual development they would have in 4 parts. Parts 3 and 4 have already been answered at the 03 hearing, with one critical exception. And I'm going to point the exception out because I think it's critical as to why this court really needs to consider what the full text of the remand says. On page 11, the last bullet point under part 4, they would have the court consider what new evidence of Nikki's medical history and condition has been proffered since 2022 and needs to be admitted into evidence and or further developed through live testimony. Your Honor, that was the issue brought forward in the 6th writ. Their new diagnosis for Nikki and why she passed away. That writ is not before this court. That right there cannot be factually developed by this court. That writ was dismissed by the CCA as under section 5. This court is jurisdictionally barred. That is dead letter clear from the CCA's remand. Then just turning quickly, Your Honor, to parts 1 and 2. There again, it goes back to the point that those parts bring up questions that are simply legal application of Rourke to the facts developed at trial and then the facts developed at the hearing. Had that 03 hearing not happened, I think this would be a different situation. Had this court not already developed the facts before it. But Your Honor can go back and read the testimony from the 03 hearing. It would be, I would assume it would basically be identical to the 03 testimony that would happen, now, because frankly, what also interesting, Your Honor, is the applicant has not stated how the science has changed since that hearing happened. And more importantly, since the CCA ruled in 2023. You can't find it in the 05 application, the change in the science. But, and then one other finally, a very minor point, Your Honor, but I do just want to point it out because I have not had a chance to respond to this pleading yet. But I just would point out that it would have, opposing counsel, applicant rather, would have the court sign on page 2, the proposed finding, it would have the court sign something that says that the state relied on dissenting opinions in both applicants and Andrew Rourke's cases without appropriately citing them. And while there's 2 things there, Your Honor, the first is we did not cite to the dissenting opinion in Rourke's case at all. I've checked the brief and it's not there. But also you can even see in their citations, the string quote they provide, none of those citations are to Mr. Rourke's opinion. There are to the Rourke opinion. They are to Mr. Roberson's opinion, or the ex parte Roberson opinion, which they do note that. But I would also point out that it is true that for every single site that I pointed to an opinion, I did not give the typical concurring dissenting site. What I did instead, and I think opposing counsel knows this, but what I did instead was include a very lengthy footnote that explained what every single concurring in a dissenting opinion was. Of course, those are not the majority opinion. The majority opinion is the per curiam. That's the 4 corners document. Everything that anybody cites from any of the judges in particular is just for consideration. But what I did was explain what those opinions are because frankly, Your Honor, they're all, Judge Richardson's is the only one that's titled concurring only. Everybody else's is titled concurring and dissenting, and it's important to understand they're concurring and dissenting to different things. And so it would become laborious to just say concurring, dissenting, concurring, dissenting, concurring, dissenting. It's more important to read what are they actually trying to get at, and they're all getting at different things. And it's a fair point. But I mean, interestingly enough, they point out Judge Gary Parker and Keel's opinions, but they don't note when I cited to Judge Finley's opinion, which is also a concurring and dissenting opinion. Judge Keel, for example, lists hers as a dissenting opinion only, but it is a concurring and dissenting opinion, just like the others are. So much happened in that remand order. And so they were having to parse out, I agree with this, I disagree with this. With that, Your Honor, I will.
Well, let me pick up there because I agree with you. A lot happened in the remand order and the opinions attached to it. But one thing that I felt like didn't happen was the provision of a nice, clean, clear set of instructions to the trial court. And I found myself going through this and reading your answer. I think you say several times this is really just a question of application of law. And we had, I forget which judge it was now, said the same thing, and there's no reason to send it back to the trial court. And then in contrast, you mentioned Judge Richardson, and his opinion, he says explicitly, and one other judge said too, yeah, they got to send it back for an evidentiary hearing. Why are we here if this is just a question of law? And if it's not, if we have at least some number of judges saying that the record ought to be expanded, is it as simple as looking at what happened in 03? Is what is it? Why are we here? Assume for a minute that maybe your argument that I'm not 100% on board with your argument that there's no evidentiary hearing necessary. If that's the case, why are we here, and what do you think needs to be expanded, and how would it be expanded?
Fair question, Your Honor. I will say that, I've been doing state habeas work now for almost 15 years, but that this is actually, it is oddly a very specific remand order. They were extremely explicit.
Well, I guess it's specific in what it doesn't allow, but not in what it does, why we are here.
Exactly correct, Your Honor. But I think that it is, I think exactly why we're here. I mean, obviously the state disagrees with being here at all, but, to your point, Your Honor, what exactly the CCA expects to happen here, frankly, I'm not even sure that they fully agree on what they expect to happen. I think that's why you see so many concurrence dissents opinion, so many alternate opinions written. Everybody clearly wanted to have their say, and a lot of people had different says. That said, Your Honor, it is regardless of well, let me actually, not regardless of, that's the wrong way to start. You have to consider the remand, but you have to give full effect to the four corners of the document, everything that's contained therein. So again, I mean, like I just pointed out, clearly anything that's in the 6th or 7th writ, this court cannot consider. That is dismissed. It is Section 5 barred. Anything that's in the 04 application, Your Honor, at this point, even though the applicant relies on the section on the 4th writ in furtherance of the 5th writ, why did the court then not reconsider the 4th writ as well and open that up? And to that point, why did the court not also reconsider the 3rd writ and open that up and say, you know what, we signed off on facts from this court. We now need those facts to be reconsidered fully and fairly. Let's do a hearing all over again. If the court had wanted to do that, they could have done that. They didn't. They expressly didn't. In fact, and to that point, Your Honor, they could have just stayed quiet on the 3rd and 4th writ and just in the remand on the 5th writ. They didn't have to say anything about the suggestions for reconsideration in the per curiam opinion about the 3rd and 4th writ. They did. They were express about it. So that this court has to give effect to that express opinion. So what I will, but to be fair, Your Honor, to Your Honor's ultimate question of like, what is left to do? What is left to consider? Well, I think one thing that's clearly left to do is to, I mean, it's in their order. It is, what does this case look like in light of ex parte Rourke? And so again, the state's position is the factual development that needs to happen has already occurred. Seemingly what the CCA would have the court do is go back, look at especially the 3rd writ hearing and see, does Rourke change its analysis of what happened? Would that cause the court to reconsider the findings that it put forward in 03? And if it does, put forward new findings. Now, to the degree that the court does feel that factual development needs to happen, then, Your Honor, I think the only factual development that could happen, if any should happen, I think the only factual development that could happen is, what is the change in shaken baby syndrome / abusive head trauma? What is the change in science since this court entered its findings of fact? What is the change that's happened? And how does that affect the court's facts that were entered?
All right, Ms. Swin, let me let you weigh in on this.
Thank you, Your Honor. I think I could start with one concession, that I think there is some logic to suggesting that there's a wall that came down with our 06 and 07 evidentiary support for distinct claims. That what the court did is wanted to go back to the moment when ex parte Rourke is decided. And our whole argument is the legal landscape changed because of a recognition of a fundamental change in the science underlying shaken baby syndrome dating back to Mr. Roberson's trial. And the support for that is evidence that is referenced in the 05 application. It's not just the evidence that was developed in the 03, but also in the 04. But I think one thing that I sense the state is trying to wall off are yet more medical opinions, particularly from Dr. La Posada, that were attached to the 05. Dr. La Posada did not offer a new cause for Nikki's death. And this is, I think, a misconception I see throughout the state's answer. They argue that we keep changing our argument about what caused Nikki's death. And in fact, that's blatantly false. There's no expert that ever said Nikki had meningitis. There is an expert, Dr. Harry Bennell, who offered a detailed declaration back in 2016 based on the limited information he'd had access to, that Nikki's death was not a homicide. And one of the things he pointed out is the change in science that had identified many naturally occurring phenomenon, such as meningitis, that can cause the same intracranial symptoms that Nikki had that led to the diagnosis of shaken baby, and that the state is now trying to recharacterize as just abusive head trauma writ large. But that's one of the things that's so important here. There was no such thing as an abusive head trauma label in 2003. Nikki was diagnosed with shaken baby syndrome. And this whole idea that there's instead overwhelming evidence of a battery is just a false representation of the objective medical evidence. But I see that the DIC was part of the 03 evidentiary hearing. It's just because they rejected it, it wasn't mentioned in those findings. As if it hadn't happened, we brought a specialist in bleeding disorders to explain more fully how someone with DIC, which is sort of indisputable based on the medical records, someone with DIC can bruise simply by touching them, and that they also are starting to bleed profusely under the scalp. And that's the whole point here, is that the bleeding inside this child's head, which was mostly not there when she arrived in the hospital, was interpreted 2 days later as a sign of inflicted trauma. But the science has changed, has revolutionarily changed, as recognized in ex parte Rourke, that you can't make those presumptions. So I think if you wanted to say, okay, you can't come in with any new experts, any new evidence that you didn't mention in the 05 application or the 03 proceeding, we'd live with that. I've never participated in a death penalty post-conviction habeas proceeding where a judge is barring you from bringing in evidence to prove your claims. That's not normally how it works. But if that will speed things up, we're willing to live with that. The other issue here is that those findings that they want to say you're bound by are the exact thing that don't hold up to scrutiny when you look at Rourke. The judge found there was no material change in shaken baby syndrome. But in fact, in 2003, the American Academy of Pediatrics was telling everybody, when you see the triad, you can just diagnose abuse. You don't need to look at anything else. And there's no argument to be made that anybody did look at Nikki's medical history, her 104.5 fever and her viral illness, the prescriptions she'd been given, Phenergan and codeine, the shortfall, none of that was considered. And that is the big change, that now no expert with any credibility would suggest you can jump to an abuse diagnosis, whatever you want to call it, abusive head trauma or shaken baby, whatever you want to call it, you cannot make that diagnosis without first doing a differential diagnosis that looks at all the credible explanations for the child's condition. And then that adds up to opining about cause of death. But we haven't changed our theory about cause of death. What we've found in response to science, which has continued to evolve since we filed in 2016, that there are multiple explanations for Nikki's condition that were never considered, and that there's overwhelming scientific consensus now that there's doubt that shaking ever causes that condition.
All right, so I guess I hear you saying that maybe the line is not as clear as the state is arguing between the types of evidence you would offer in support of the science having changed about shaken baby and evidence that would also show another potential explanation. And I'm trying to, what then do we do with the restriction that the court has put on us that we're not getting into these other claims? And I think alternative explanations fall under those claims. If we're really just focused on, has the science on this issue changed? Does it matter what anybody's ultimate conclusion would be? Or are we just looking at, has the science changed in such a way that we know this would likely produce a different result?
Well, Your Honor, the whole point of Rourke is that there were no alternatives considered. That is the change in science. And that's what I'm saying. To suggest we can't put on evidence of other explanations of Nikki's condition is to ignore the change in science that was recognized in Rourke. It's the degree to which we can marshal an army of experts, which we have, to prove up those changes and specifically what was missed in Nikki's case. But that's the science. It's just like in Ex parte Robbins, the change was merely one medical expert saying, oh, I know more now, so I wouldn't have been so hasty to say this was a homicide. Well, we have, a paradigm shift in this whole understanding of, can you diagnose abuse based on medical findings? And we amassed a lot of this evidence, all of which was rejected on the premise that shaken baby syndrome hadn't changed since 2003, which is just not something that can withstand scrutiny in light of ex parte Rourke.
But I guess, and maybe I'm not asking it well, but I think my question is, isn't there a difference in having your expert potentially say that based on the science, looking at this now, there are alternative explanations, and having an expert come in and say, based on the science, there are alternative explanations, and this is the alternative explanation, and we can prove she actually died by A, B, C, D, and the death was caused by this particular. Are those not two separate?
Your Honor, I don't see it that way. What I see is that we've been barred from trying to prove up an actual innocence claim, and that there was a dissent by presiding Judge Shank saying we should already, not only had we met that burden, that we should already get a new trial. And Judge Finley, also a member of the majority, thought that should be a remanded claim. There may be reasons for that have nothing to do with the science. And ultimately, really, the only legal difference is if Mr. Roberson was found actually innocent, he would be entitled to seek compensation, etc. So that door's been slammed. But the evidence that might be relevant to an actual innocence claim is almost all still relevant to the changed science claim because of the materiality element in an Article 11073 claim. Because what it does is it allows you to attack the integrity of anything the state is relying on to say the conviction is valid.
And that right there, go ahead, Jerome.
I would say it doesn't allow you to attack the integrity of anything. The statute's pretty clear on what you can and can't attack. It's the underlying science of it, not. I mean, when you talk about bringing in actual innocence claims, and I mean, you very quickly get. You can draw some lines connecting various claims to actual innocence and what we're here on, but those lines start to get long and they start to get pretty thin. And I wonder if that's one of the reasons the court did what they did in giving that instruction, is they want this to be very, very limited and not to get too far afield. And I also wonder if they're given the chief judge's recommendation that in his mind this should be a new trial, if anybody's thinking that this thing needs to be addressed, then obviously we're decades out at this point. The sooner you get to that point, the better. And the longer it takes to develop a record here, the longer it's going to take for them to review and reach whatever conclusion they ultimately reach. I mean, is this not really in your client's interest to make sure we stay limited and stay focused so we can get this done, get it back to them, and they can make whatever decision they want?
Your Honor, if what you envision is, say, opening an evidentiary hearing where we're given an opportunity to admit the evidence we've already attached, and that you say, okay, you can't bring in anything new, that could be done in an hour. I have done that before in proceedings, for instance, when it involves Atkins claims and the state recognized there's a pretty strong reason to believe this person has intellectual disability. So we could do that. We could say, open the evidence, and then even if it remains adversarial, that both sides do propose findings based on what is then in the record. We could do that. And I agree with you, Your Honor, delay is not in Mr. Roberson's best interest, but also being hamstrung in terms of what evidence we can rely on to prove the elements of an Article 11073 claim. That's where I'm reacting. That we can't just assume that what's laid down in findings that are premised on a fundamental fallacy, that there's no change in shaken baby syndrome, cannot be the starting point.
Well, and Mr. Bragg, I'm gonna give you a chance because I know you've got some stuff to say here, but let me ask this before I do. What would change from the evidence you've already submitted in these various writs? What do you have that has not been submitted that you would need an evidentiary hearing to do? What is out there that's new, that's different? Why isn't this? Why wouldn't it be sufficient to just look at what's already before the court and make a determination of if and how ROAR complies to what's already here? What are you missing? Ms. Swin, are you there, or did I?
Oh, I'm sorry. I thought you were addressing Mr. Bragg.
Oh no, I'm sorry. I'm trying to nail down. I mean, tell me. So we have a hearing tomorrow. Who are you going to walk in and have? What evidence are they going to bring? What's not here that?
Well, Your Honor, I mean, I think the fact is that the more one studies this case, I mean, there are constantly more things that were obviously missed that would be part of a differential diagnosis in 2026. But I think we can more than prevail if we simply get a fair hearing on what is the change in science that was recognized in Roark and admit all the evidence for consideration that's already been attached to or admitted during the evidentiary hearing in 03, 04, and 05. Because 05 incorporates, it doesn't have new evidence related to cause of death. That's part of 04, 03. But none of that is really, the science is the same argument. Shaken baby syndrome was premised on this idea you can diagnose abuse based on certain conditions, and therefore nothing else was considered. The science now is absolutely you consider it, and SBS and AHT are diagnoses of exclusion. So it's a complete flip, and that is recognized in Ex parte Roark. Ex parte Roark, they didn't even try to explain what had happened to this child. Luckily, that child lived. But there certainly was evidence that she had sustained a short fall with a head impact, that she had some kind of unexplained medical conditions. But the whole point was just knowing the science has changed was enough to get Andrew Roark a new trial. But there was also lots of testimony about bruises on her and this, that, and the other. None of that was dispositive. What mattered was the change in science and all the things that weren't considered in light of the new science. And we could, Judge, Your Honor, I would say if you want to have the evidentiary hearing next week and limit us in that way, we'll be ready. But we have to be able to at least rely on what was pled in the 05, is all I'd say.
Mr. Bragg?
Yeah, I would pick up where my opposing counsel just left off. That's actually our point, Your Honor. What she just said is critical here. that yes, the science has changed since the time of trial. This court even recognized that in the 03 hearing. That's in the findings that were adopted by the CCA. But as opposing counsel just said, the 05 application does not rely on new changes in science since the 03 and 04 applications were filed. There's no new factual development that occurs there. It is a legal it is a recognition. It's just like Ms. Swin said. It is the recognition that Rourke provides of this change in science. But even then, the change that's at play in Rourke was at issue in the 03 hearing. That was where the adversarial process happened on what this change was, testimony about what was what the medical experts and the medical fact witnesses testified to at trial, what the change has occurred since then, and whether or not it still holds up to scrutiny. So, I mean, that right there is actually the crux of the state's point. I would just respond to, a couple of things. Well, actually, 2 points that kind of work in tandem. The first is that, she said that opposing counsel said that they haven't changed the theory of the cause of death. And look, to opposing counsel's point, since this set of attorneys has come on to Mr. Roberson's case, they have advocated, to their credit, they have advocated vociferously for his innocence. But that was not his claim at trial. That was not his theory of her death at trial. At trial, his theory of her death was just that he shook her. And that was what caused her death. The state's theory, and this goes to, the claim that opposing counsel made, the state's now recharacterized or trying to reposition itself. The state has been in the same position all along, that this isn't just a shaken baby syndrome case, that there was external impact that occurred. And those impacts led to her death. That's how it was indicted. That's what the evidence that the state put on was focused on. And, Your Honor, I've quoted a lot. There were big swaths of the closing arguments that I put in my brief. I recommend you go read those closing arguments in their totality from the guilt phase. And that will show you the picture of what was presented at trial. And 11073 tells us that they're hemmed into that. Now, I know, I know that really grates opposing counsel that I'm saying that, because they did present a claim that trial counsel was ineffective in the presentation of that case. They shouldn't have presented that case, whatever. But that claim is no longer present. That claim is not before this court. And so 11073 tells us that if there was a change in science, we have to take it and we have to apply it to the totality of what occurred at trial.
Your Honor, if I may, if you want to look at a seminal 11073 case, I recommend Ex parte Cheney. Essentially, it's about the junk science around bite mark comparison. But importantly, the evidence adduced in that proceeding was about all the other things that undermined confidence in the conviction, which they were allowed to put on and which the CCA considered in its opinion. And I think to try to say the trial is locked in is not an honest or appropriate way to go about this. And to hang on the legal fiction that because Mr. Roberson's very ineffective counsel ignored their client's protestation of innocence and was mad at him for not accepting a plea deal, then told the jury not to believe him, but to believe, yes, this was a shaken baby case. That wasn't Mr. Roberson confessing to shaking her. That is not an honest way to look at this record. Also, it's not honest to say that there was nothing, that the case relied on more than shaking. Yes, there is evidence of an impact. That's one place we agree. But even their experts at trial didn't agree. The only expert who looked at the CAT scans of this child's head in a head injury case said there was one minor impact site. That was Dr. Squires, which is why she had diagnosed shaken baby syndrome. She diagnosed it. The medical examiner who never looked at those critical CAT scans or anything else, claimed there were multiple impact sites, which she defined as various parts of the internal bleeding. And has never been able to point to anything more than the bump on the back of Nikki's head captured in the CAT scans. She's made numerous admissions under oath that need to be taken into account, not just accepting her very irresponsible trial testimony that then was taken up by the prosecutors, who then exaggerated even more. And I find it interesting that Mr. Bragg is referring you to the closing argument. I mean, the closing argument is unhinged. I mean, it just imagines this shaking and beating episode that nobody witnessed and is contrary to the state's own evidence, including the photographs taken of Nikki when she arrived in the hospital. It also contradicts the observations of the prosecutor himself during trial, where he pushed the medical examiner. He's like, well, I'm not seeing, blows on the outside of her head, because we all know what it looks like if you punch somebody in the face. And the medical examiner gives this convoluted thing about how she has a weak neck because she's a toddler and it's shaking, and that's why, and the blood is the internal blood vessels breaking during the shaking. I mean, it was a shaken baby case because there was not evidence of a battery. So people can say whatever they want, particularly in argument, but as Your Honor knows so well, that is not evidence. And so we can't have this fiction about a trial that produces coherent case that really never happened. It was a shaken baby case based on the presumptions that the science of the day allowed that went uncontested by this defense lawyer against his client's claim, including in notes that were seized from his jail cell by the state's investigator and part of the trial record. So I appreciate Mr. Bragg acknowledging there is evidence of a real failing there. But it's not like we're trying to argue the McCoy claim. We're just saying, let's not lie about what really happened to try to win in this case. That's not the way we should be proceeding.
And if I may, Your Honor, I would just like to point out, everything the opposing counsel just argued was all at issue in the 03 hearing. Everything that she has said was all at play. It was all there. It was part of the adversarial hearing. They put on their witnesses, state put on their witnesses, this court entered findings. And I, to opposing counsel's earlier point, when I talk about the findings in this court being locked into the findings, I don't mean the court simply just absolutely must sign that same page and send it back. You don't get to think about it. That's not what I mean to say. What I do mean to say is you have to wrestle with the fact that those findings are there. And what that means, I think the only way to read it, and especially in light of the conversation that's happened today, where again, all of the facts that we're running over, all the facts that we're discussing, were all at play at the hearing in 03. That's when Mr. Roberson got a proceeding that looked just like what happened in Ex parte Cheney, where everything was at play, including the actual innocence claim, was fully before this court. It was a full court press for it. The only thing they didn't have was Rourke. Now they have Rourke. And, fair enough. But I think then what that means is, again, the only way that I can read what the court has done here is to say, take Rourke, apply it to this court's findings from the 22 hearing, the 03 hearing, and see if it changes your analysis.
And Your Honor, I think that may be a good roadmap, that if we were given the opportunity to go look at those findings and take each one of them and see if they withstand scrutiny in light of both the trial record, the writ record, and Rourke, we could go through each one. And interestingly, there won't be anything, there's nothing in the findings about Dr. Kelly Goodness, which dominates a huge part of the state's answer. There's nothing from any of these lay witnesses. There's nothing from Brian Wharton, who's recanted all of his testimony. But there also is nothing from our experts. It's as if the science that we adduced in the 03 proceeding didn't happen. And that's part of the problem, a misleading summary of the 03 proceeding was sent to the CCA, and it relied on that materially misleading document to Mr. Roberson's detriment. So we could do that, and we could go grade those papers And then you're not decide, you know, this still holds up, and then we go from there.
All right, so and correct me if I'm wrong, but it sounds like there's at least some consensus that there are a substantial bit of evidence and facts already developed in the record, and that the real argument is over what they mean and how ROARC applies to them. And there is not, I haven't heard yet, a need to bring in necessarily new people, new experts, new fact witnesses, anybody to further develop evidence. So what we're really talking about is there's enough here, and we have a dispute over how ROARC applies to it, which was sort of my initial question that I think you answered, Ms. Swin, that there's not a whole lot of people that if we limit the hearing, as we talked about, there's not really anything your client misses out on. Understanding there may be some things you'd like to bring, but is that a fair summary of where we are as far as how the court should be viewing where we're sitting here today? Because I appreciate the discussion, and obviously y'all are gonna have ample time to do that, written or orally. But what I'm really trying to figure out right now is sort of next steps. And so if we are in agreement that it is procedurally proper and feasible for the court to take, whether it's from 03 or 03, 04, 05, take that already admitted evidence, get it admitted, considered in where we are now, and then let's hash out how ROARC does or doesn't change things. Is that where we are, and is that the path we should go down? Because I think that's what I'm hearing both sides sort of talk around and maybe agree on.
Your Honor, yes, and that agree that if we admitted all the evidence referenced in, you know, 03, 04, 05, just in a pro forma manner so that Your Honor could consider it. The only other thing is if the state is going to rely on what we feel is irrelevant trial testimony, like the punishment phase, I mean, that is built on the conclusion that Mr. Robertson was not wrongfully convicted. It's built on the premise that he committed capital murder. And so none of that, it's everybody that gave testimony, they're informed by that. That should be off the table. Likewise, the stuff that even Judge Evans concluded wasn't worth mentioning from lay witnesses. You know,
Well,
but if they want to rely on all the Palestine personnel, well, we ought to be able to at least argue from other evidence what's wrong with their testimony without bringing in new people.
Sorry to interrupt you again. I think we just lost Mr. Bragg.
Whoops.
I think I'm not seeing. Is he showing up on your screen? Because I don't see him.
No.
Okay, let's give him a minute. See if he pops back on. I'm going to step into my office for 1 second, see if my coordinator's heard anything. She's in the other room. So let me see if he's called or reached out to her. If y'all excuse me, I'll be right back.
No problem, Your Honor.
All right, I think we got Mr. Bragg back now.
Yes, Your Honor, apologies, there was a up connection again, but I am back.
No problem. It happens. I think I didn't notice exactly when you cut out. But I think Ms. Swin was saying that she was thought it was appropriate to move forward with an admission of, well, I think her position was all, but at least some of the record from 03, 04, 05. What's the state's position as far as procedurally what the next step here is?
Yes, Your Honor. The state would agree that I mean it's kind of the state's point in its brief in its answer, Your Honor, that that is exactly what the court has to do. Take the evidence. I think especially the evidence development has occurred at the 03 hearing and apply it to work. So then we can certainly submit argument on that, how that application occurs, and what the outcome of it is.
All right. Do you agree that it's appropriate to submit 03, 04, and 05?
I mean, well, Your Honor, I will say it is the 04 writ does provide some consternation because your opposing counsel makes a valid point that it is including the 05 application as an underpinning. But the court also, upheld the dismissal of it. So but it's kind of the same position that I think the court is in with the 03 writ, correct, which is kind of why we're here. So I do think it is at least fair to say that yes, the court needs to consider the 03, 05 proceed, everything's there, and then or find it necessary to include something specifically from the 04 writ. May have to do some. There may have to be some argument on how exactly a procedural bar in that writ applies or affects that analysis.
So I'll tell you, my thought is it's easier probably if we admit all of it, and then both sides obviously can argue about what's actually applicable or how much weight to give some of it, but that way we're not piecemealing a record. And since it sounds like there's agreement moving that direction, procedurally, what do y'all think needs to happen to make that occur? Do we need to have a formal hearing? Can we have an agreement that it's admitted and the court can consider it? How do y'all feel most comfortable moving forward on that issue?
I think in a simple agreement, and then we have the state court records as they exist at the CCA. We can submit that to the court. That would include everything, I believe, and we can just submit that as copies of discs to the court.
Ms. Swin, does that sound reasonable to you?
Your Honor, certainly I think an agreement memorializing an order from you that everything attached, the 03 record, 04, 05 is being admitted and available for consideration. I think then, I mean, you can do that, but I think then you might want to give us some homework and we go ahead and set a hearing where we also come in and argue at least one tranche of this.
Well, my thought is sort of step one, since y'all are may or may not have shown up expecting to do this today, to give y'all just a little bit of time to make sure to review 03, 04, 05. My preference would be for the parties to confer, make sure y'all are in agreement as to it's all getting admitted. And if y'all memorialize that agreement, then the court will do a formal order taking notice or admitting those documents. But I don't want to necessarily pin everybody down unless y'all are certain there's nothing there that y'all need to review before you agree to it. But I'm happy to give you a week or so to talk and make sure there are no issues.
Your Honor, I'm fine agreeing to the admittance of the 03, 04, 05 writ right now, just as long as it's clear that there will be argument as to what exactly it all means. But yeah.
Absolutely. Yeah. So it'd be admitted for potential consideration, and what consideration it merits ultimately will be left up to y'all. And I'll get something in writing to that effect today. Then, as far as timeline for any written argument response, Ms. Swin, I'm not just ignoring your request for a hearing, but my preference, I think, would be to get a written response from both sides so that one, I can better determine if a hearing is needed, and two, if a hearing is needed, we can maybe pare down what the issues are at that hearing for argument, so that y'all aren't having to prepare for things that maybe I feel like are not necessary, or y'all can better schedule time, how long that's going to take, and what it's going to look like. Does that work for both sides?
Yes, Your Honor.
So I'm just making sure I understood you properly. You're going to want a written submission after you enter this order of some kind. The scope of that I didn't follow.
Yes, yes. Basically, a written argument as to how to apply ROARC to the evidence that's now been admitted from 03, 04, and 05. And as part of that, as I said, I don't want to, I'm not dismissing or denying any request for a hearing at this point. But if my hope is that would help all of us identify what, if any, issues would actually benefit from a hearing and oral argument before we just set it and assume there's going to be blanket argument if it's not necessary.
That sounds great, Your Honor. I mean, I think if we're ordered to submit briefing on that fundamental question, how does all this evidence have anything to do with Rourke? You know, and if you want to put that in the order and give us a deadline, just don't give us a page limit.
All right. Well, Mr. Bragg, I think you're leaving for a while. Is that right? You've got a trip?
Yes, Your Honor. I'm out for 2 weeks, and I also have a couple of things coming up in another subsequent writ proceeding. So, yes, Your Honor.
So what is and Ms. Swin, I know you probably have other things on your calendar too. What's a reasonable sort of timeline to set for getting the briefing in?
Oh, a month from now, or
the state would ask for 45 days, Your Honor, just because for the next two, like literally as of Monday, I will not be looking at this case until 2 full weeks. So
I was thinking probably closer to 6 weeks, given that it sounds like you're out for probably a month. That gives you a little more time.
that would be helpful, Your Honor.
Something maybe May 22nd or 29th looks to be about 6 weeks.
And Your Honor, if I could ask that if we're going to go out that it could be May 29th, because I have another big deadline on the 22nd.
Absolutely.
Thank
All right,
you.
we'll do May 29th. All right, and I will get this out. It may not go out this afternoon, but it'll certainly be out by Monday morning. What else do we need to take up today?
Nothing from us, Your Honor.
Nothing from the state, Your Honor.
All right. Again, thank y'all for your patience with getting this started today, and we'll get that order out. And if y'all can see what, well, I guess we'll assume 03, 04, and 05 are going to be admitted in full. We'll get that order taken care of, and I'll look forward to getting y'all's written briefing by the 29th.
Thank you,
And
Your Honor.
real quick, Your Honor, if I may, do you need those provided to you, or do you have, because I know there was, maybe some pleadings and stuff that were available at the CCA that weren't necessarily filed in this court, or do you need this?
So I have gone back and pulled, I think, from just about all the filings, everything from the CCA. If y'all have stuff in a clean format that you want to submit, so that it's all together and we're all on the same page about what exists, and we want to make sure we're all looking at the same things, that's great. But I know y'all got a lot going on and are doing a lot of work. I don't want y'all to have to duplicate anything or recreate stuff needlessly. But that's the one caveat is I've been pulling it off the CCA website, taking stuff out of y'all's filings, and then stuff that was filed, of course, in Anderson County. So I've got it sort of piecemeal. If y'all have something all together and want to admit it as sort of one file or one group of files, great. Happy to receive it. But I don't, as I said, I know y'all have done a lot of work on this and the other things y'all have pending. So
depending on what, sorry, I don't want to cut you off, but I don't want to overly paper this record or overly complicate this record. So I think what we could do, if it's amenable to opposing counsel, is I think we could assume that we're all working with a complete set of records. And if there is something in our briefs, if I include something or if opposing counsel includes something that either the court doesn't have or one of the parties doesn't have, we can make sure to get that document out to everyone. But I don't know that Ms. Smith, what were you going to say?
Yeah, Mr. Bragg, that seems reasonable. And I think, Your Honor, we just sent you a large volume of the pleadings that we had also shared with Mr. Bragg. The only thing I'm not sure of, and perhaps my co-counsel, Ms. Lynn, can verify, is that that includes the evidentiary hearing transcripts from the O3, because that would be really fundamental, because that's not something you can get from the CCA as easily.
Well, I've got the O3 volume in front of me with its attachments that y'all sent, and I don't see transcripts in this particular notebook. It may be
Right.
in one of the other notebooks, but
Because there's the O3 application, which is the pleading with attachments, and that's pretty big. But then there's the massive evidentiary hearing record that was developed in 2018 and 2021, and that's later in time. And I don't know that we did. Emily, did we send that?
We did, Judge, it's behind tab 5, but it goes, there are evidentiary hearing reporters record tab 5.
what binder number are you looking at? I'm sorry.
I'm looking at binder 1.
Okay. All right.
And it probably goes into a binder 2,
It does.
3, et cetera.
It does. It starts at binder 1.
Okay, perfect. Then I will, I've got that then.
Perfect.
All right. Anything else? If not, y'all enjoy your weekend and thank you for being here.